All right, folks, this is George. I'm founder of Solo, and we are live. This is the Debt Hotline. I'm here with Greg and Weirden. Greg, how's it going?
I'm good. How are you? Happy to be here.
Nice. Fantastic. Glad to have you on. Uh, Greg is the CEO of Debt Brief, and he's a practicing lawyer here in Utah who has been on both sides of collections a little bit, right, Greg? You've helped out collectors. You've also helped out consumers, especially. That's what you're doing with Debt Brief currently as well. Is that right?
Correct. Yep, done it on both sides.
Fantastic. Uh, Folks, we have lots of people watching live tonight. If you have a question that you want to get in on the hotline, you can just call in at 801-613-8181, and we will go ahead and take your questions. You're also welcome to just send in a question on the chat. We'll do our best to get to that. But the best way to skip the line is just to call in live, and you can chat with me and Greg here, and it'll be a fine time. Uh, Greg, so the topic tonight is uh, how to deal with bankruptcy. What kind of tips do you have for people who are coming into the situation being sued for debt and are considering bankruptcy?
I mean, my thing about bankruptcy is, and you may have guests on here on the debt hotline that think differently than me. My background is, more the litigation side of it, right? Rather than bankruptcy. So what I always tell people is if you're thinking of bankruptcy, and bankruptcy can be a good idea for a lot of people. But I think that before you move to bankruptcy, you ought to at least try and settle your debts, right? So I talk to a lot of people and a lot of times people are just like, "Oh my gosh, I can't pay this bill. Should I just file for bankruptcy?" Like if you've got one or two bills that you're having a hard time paying, you really ought to try and settle those before you just go to bankruptcy, right? Using a tool like Solo Settle, I think is going to be a really good idea for something like that. Now, obviously, if you are to the point where it's like you have so many debts or such a large amount of debt that like it's just going to become unmanageable, there's no way to reach settlements and all of these, like that's the point where you're going to move to bankruptcy. But my experience is a lot of people, I think, just immediately jump to bankruptcy when you don't necessarily have to do that as a first step, right? There's other things you can try and do to manage this debt collection situation before you get to bankruptcy. But of course, that's
Nice.
coming from the lawyer's perspective that does the litigation, not the bankruptcy part of it, right?
Sure. Yep. That's everyone has their angle. That's for sure. Uh, is bankruptcy good at stopping litigation or garnishment?
So yeah, if you file bankruptcy, that's going to stop all the collection efforts. So if you're getting sued or your wages are getting garnished, like filing bankruptcy is going to stop everything right there until that bankruptcy, goes through the bankruptcy court and that gets resolved. But that would stop things at least temporarily.
Right. Okay. Yeah, that's good to know. So it can stop things like garnishment, etc.
Yep. Yep. But again,
So
there's
say
there's other ways to.
a bankruptcy stay stops garnishment now.
Yeah, should. Yeah, it's going to stop all those kind of court
Uh,
collection
are,
efforts.
are judgment debts? But let's say so garnishment. There's a judgment.
Mhm.
Is a judgment debt dischargeable? Does it just depend on the type of debt?
I mean, it depends on the type of debt, but just like a general consumer debt judgment, then yeah, that is going to be dischargeable in bankruptcy, depending on the type of bankruptcy. And I'm probably not the best person to talk about the different types of bankruptcy,
Hmm.
and that, but generally, like consumer debt judgment is going to be dischargeable in bankruptcy.
Yeah. Okay. Uh, Great. So, folks, that's a quick little summary on bankruptcy. The hotline, we're dealing with anything that people want to talk about here that are here live. So if you have a question, call in at 801-613-8181. and our friend Brandon will take your call and then plug you in to the stream here. It's real easy. We have somebody who wrote in before the show. That's Daniel in Washington. Daniel says, I recently submitted a full dispute regarding an $8,500 student loan repayment that originated with National Collegiate Trust. This loan has been bought and sold by numerous different debt collectors. Can you explain how different creditors buying and selling these loans work? If and how I can still be liable, and what next steps I should expect if the suing attorney has a solid case against me versus what kind of response they might have if they don't have a great case. Also, any tips on how to find a suitable attorney in my area if I need an attorney would be helpful. Greg, what do you think?
Okay, so you've got this loan, $8,500. It's been bought and sold multiple times, which, George, I'm sure you've seen this. That can be pretty common, right? So the thing about that is when they sue you, they're going to have to prove two things. The first is that you owe the debt. So do they have the documentation with the original loan documentation showing that you signed the documents for the loan? Do they have documents showing like the ledger, what was paid, how interest accrued, that kind of stuff? Like that's going to be their proof for that you owe the original debt. But they've got to prove the second thing, which is that they have the right to collect on that debt. And they're typically going to do that by showing the purchase agreement. Now, I would say in most cases, when I see this kind of stuff, it's been sold once, right? So you have the original creditor and it gets sold to a third party junk debt buyer. And so there's got to be a contract between those two. And that contract is going to be the proof that they have that the third party debt collector has the right to collect on the debt. Now, if it's been sold multiple times, 3 or 4 times, they have to show the chain of custody of all of those. So they're going to need, if it's sold from original creditor to debt collector A to debt collector B to debt collector C, there has to be a contract for each of those, right? I would say in many cases they don't have that. But they may. Here's the other tip that can really help you win a case like this too. In most cases, when you're in like a regular state court, so not small claims, but if your case gets into regular state court, the courts have what are called rules of evidence. And these are the rules of how the evidence has to be presented. So they can't just walk in and the lawyer says, well, here's the original loan agreement with the ledger, and here's contract from original creditor to collector A, and here's the contract from A to B, and here's the contract from B to C. You have to present evidence through witness testimony. So they are going to have to bring witnesses who can testify that, yes, I work for company A and this is a legitimate actual copy of the agreement, the purchase agreement or the sales agreement. And those people have to have actual knowledge of like, yes, I work at that company and I've done my research and I know that that is the actual copy of the agreement. It is so unlikely that debt collector C is bringing someone from company B, from company A, from the original creditor who can testify to the authenticity of these agreements. So if I'm defending that case, what I'm doing is I'm going into court for that trial and I'm going to say, number one, you don't have all the documentation you need to show chain of custody. And even if you have the documentation, I'm objecting to you presenting it as evidence because you don't have witnesses who can testify to the authenticity of those things because you didn't bring witnesses from all of those collectors. So to me, from the lawyer's point of view, if it's been sold multiple times, I'm like, I am very confident that I can win that case in court.
Great. Can you tell some success stories? You got some success stories from the vault?
Yeah, I think definitely what you do is you get sued, you file your answer, and then I've had people where they'll send like a request for production of documents form, right? You send that form and it says, I want to see the purchase agreement from company A to B, from B to C, whatever. And a lot of times they won't respond, and I've seen it. I've had success stories where you send that and they know they don't have it, right? They're expecting to get a default judgment, and then next thing you know, the next communication from them is the withdrawal of the case, right? I mean, I have definitely seen people go into court too where they try and present their evidence to the judge and there's an objection that says, I object to that evidence coming in because you don't have anybody testifying to the authenticity of these documents. And the judge doesn't let those contracts in. And without those contracts, they can't prove chain of custody and win. I mean, I've definitely seen cases won by using this kind of argument.
Cool. Nice. Great. Another question from Antonetti in Arkansas. How do I get an attorney to release garnishment activities from my bank account? I'm already in an agreement to pay them back through Solo. Interesting. Yeah. So, what do you do if you are being garnished, but you also have like a settlement plan outside of that garnishment in place?
Okay, well, I think it kind of depends on your settlement plan. And this is, I think you need to be careful when you enter into settlement agreements. And we don't know what their agreement with Solo was or whatever, right? So the only really rule that you have when you enter into a settlement agreement is that both sides have to agree to it, right? But you need to be careful because they will try and trick you when they enter into these agreements. So, the best thing that you can do is when you enter into a settlement is agree that, like, look, I'll pay you and in exchange you'll dismiss the case with prejudice, right? A lot of times they're not going to agree to that, especially if you go on a payment plan. So they may say, look, we want you to stipulate to a judgment and then we'll stay collection of that judgment while you make your payments. And as soon as you miss a payment, then we're going to start garnishing your wages. Now, what I think a lot of people do sometimes is they don't realize that they can kind of negotiate those things. So they say, and I've seen this happen. So they'll call them up and they think they have a settlement deal. And it's like, okay, I'll pay you $200 a month. And they'll say, great, but you don't get anything back in return for giving them the $200 a month. So you start making your $200 a month payment, but they keep garnishing your wages. And you say, well, I thought we had a deal. And I have seen this happen multiple times where you call them back and you're like, I thought we had a deal. And the debt collector says, we didn't have a deal. You just said you were going to make a voluntary $200 a month payment. We're still collecting from you, right? So you have to make sure that your agreement gives you the things you need back in exchange. So your agreement should be, I'm making the payment. In the meantime, you're going to stop garnishing my wages, right? Now, so how do you get rid of the wage thing? You can the best way to get rid of a wage garnishment is to enter into a settlement agreement. But you've got to give them some kind of incentive to do that, right? So if they're garnishing $500 a month and you say, look, how about let's do a settlement that I pay you $200 a month, like, why are they going to do that? So maybe you offer them a little bit more a month than they're allowed to garnish or something like that. But then it's, if I'm going to pay you voluntarily, you have to give me something back, whether that's a dismissal, a stay of, the wage garnishment, whatever. But always make sure that those settlements are two-way promises.
Yeah. And Antonetti, weighing in from Solo here, something we found is that a lot of collectors care very much about their perception and like reputation, especially because they're representing their client, which is a bank that you are a customer of, oftentimes. Right? If the debt hasn't been sold a bunch, you might be in a situation where your wages are essentially being garnished by your previous bank. And in reality, that bank actually wants you to be their customer again, believe it or not. Even though they're garnishing your wages right now, they actually want you to be their customer, and that they'd rather not garnish your wages. Right? So like there's this pretty strong interest where they would rather get a settlement payment plan than do a garnishment, even if that settlement payment plan. Sometimes the settlement payment plan need to be more than the garnishment, but sometimes they'll take something that's less than the garnishment uh, just to get a deal done, and so that they can say, uh, we don't garnish our customers' accounts. as much as some other banks, right? Is part of the part of what we've seen in this ecosystem as well. We got another question here from Dominique in Tennessee. How much uh, it looks like he's asking himself some rhetorical questions in the text. He says, "How much do you owe? How much debt do you owe?" 35,000. So Dominique owes 35,000. He is being contacted by collection agencies and attorneys. He was sued for one of his older credit card debts, and he has a hearing in November. Uh, he has other debts and collections. So there you go. He's being sued for 35K, and he has a hearing in November. So Dominic, for this situation, right? If you're being sued, 35K, sounds like you have already responded because you have a hearing. Sometimes people mistakenly uh, misunderstand the text of the summons, and they think the summons is saying they have a hearing, when in reality the summons is saying you have to respond by this date to get a hearing or something like that. Like it might say you're required to have an appearance in court on November 5th. And people think, oh, that means I need to show up at a hearing. And in reality, that means you need to file an answer, which is your appearance in court by the 5th. So make sure you filed an answer if you haven't already. And then, uh, a great path for you would be to make an offer to settle this debt. 35K is pretty a large amount. You want to make sure, look through your own records, make sure that's the right amount, and then try to figure out what kind of a settlement arrangement you can get on here. Through Solo Settle, you could do one of three types of arrangements. You can do a lump sum arrangement where you end up paying something like $20 or $25,000 in a lump sum to get the debt settled. That's a lot of money, but we definitely see people do that to have that kind of cash hanging around to get the debt settled at the best rate. Option two is a payment plan. So you'd get onto like a payment plan um, for the size of a debt, something like probably $500 a month over 1 to 3 years to get this thing paid off. Or the third option for us is a tiered payment where you can do one tier and then a second tier. So let's say you don't have any money right now, you can get onto a tier of $100 a month, and for like 12 months, thinking that you'll have income down the road. And then you can have the tier go up to like $200 or $300 so you can pay this debt off in time. So that's a good settlement option for you here. Uh, that's what I pursue. Greg, other thoughts here?
Yeah, I mean, when you're talking about $35,000 now, I mean, we started this by talking about bankruptcy, right? Like you're kind of getting into that range now where you're talking about a lot of money, but it doesn't sound like the 35K is all from the same creditor. I mean, at least the way I understood it is it might be
Hmm.
different creditors, right? So the way that I'm going to attack this first is like before I decide that like I'm just going to file bankruptcy, I'm going to try and take care of this stuff first by trying to settle these using Solo Settle or whatever. And the way I'm going to attack it is I'm going to go with the ones that suit gets filed first, right? So like you got to remember that you have no obligation to do anything until you get sued. So, the ones that sued you, those are more urgent because you got to file your answer. They can get a judgment, start garnishing wages, things like that. So I'm going to try and settle those first and, try and delay the others as much as I can. If you get too underwater, like then's the time to file bankruptcy, but I'm going to try and settle them one by one based on who's suing me. I mean, that's the way I would attack it.
Yeah, that's for sure. Yep, definitely something to keep in mind is that the lawsuit that's against you is definitely the most urgent thing. Sometimes you can get quite a bit of a delay on the lawsuit. Like if you're in California, you file an answer, hearing's probably not going to be scheduled for at least another year out in advance. So that can deprioritize that a bit. Uh, on the flip side, the other kind of the concern on that approach is that we see the lowest settlement rates on pre-lawsuit debts. So if you're able to settle before you get sued, you're probably going to get the best deal. However, the one that you're being sued for is the most urgent. And you see better settlement rates before the lawsuit occurs because the collector hasn't incurred as much cost at that point. Right. So yeah, go ahead, Greg.
I would agree with you, and so I want to make sure that like what I'm saying is not misconstrued, right? So I would agree that you can get better deals. So if you can settle all of these pre-suit, like that's definitely what you want to do. But if you're thinking I don't have enough money to settle all of these, the ones that you're being sued are more urgent, and then I'm going to get to those pre-suit ones as I can. And so like I do agree with you on that.
Yep. And part of the structure here that's important to recognize is the revenue structure for the collector, right? So let's say a creditor, let's say you had a debt with a bank for $10,000, credit card debt. That bank will take that debt and sell it for 4%, which in this case is about $40, I think. 4% of 10,000 is $40. And then, is that right? $400 because it's $400. So I take that, sell for $400, and then uh, the debt buyer will have that. The debt buyer bought it for 4%. That doesn't mean the debt buyer can settle for 4%. I don't know about you, Greg. I don't see many like 5% settlements.
No,
Uh,
unless they don't have the proof, but that is pretty
right,
uncommon.
right. They're either going to dismiss or they're going to settle
Yep.
for like above, or
Yep.
for not 5%.
Yep.
We have seen very low settlements before. I've seen debts forgiven. I've seen debts be dismissed. I've seen debts settle for very low amounts, but on average, they're definitely not settling at 5% because the debt buyer bought it for 4%, right? So
Yeah.
want to
Yep.
dissuade people from that belief. The debt buyer is only going to collect on about 30% of its portfolio, right? So in reality, it didn't buy just your $10,000 debt. It bought a portfolio for $1 million of a gajillion people's debts, just a bunch of debts. It's only going to successfully collect about 30% of those debts. And so in order to settle, it's going to need to settle for around 40 to 60% at that point in time in order for it to be basically stay in business. And so for the settlement to occur, it is going to need to have this 40 to 60% settlement. And then if they aren't able to collect from you at that point in time, they're going to hire a lawyer who's maybe going to send you a letter. The lawyer doesn't need to send you a letter. Another kind of misconception people have is like this concept that the lawyer needs to be polite and give you a phone call before they see you. They don't need to notify you. They're going to see you. And then the lawyer is going to make their money off of like a 30% commission or something like that, off of money that they collect, right? So if it's a $10,000 debt, they're going to get paid like a 30% of whatever amount they collect on that. So if they settle with you before they sue you, their costs will be quite a bit lower, so they'll be able to settle for less. But if you settle with them after they sue you, they have to have paid the filing fees for the court, have to have paid their lawyer billing hours, etc., for like actually getting it filed, and so they probably aren't going to be able to settle for as low of a rate. So those are some economics to keep in mind. Does that sound all accurate to you, Greg?
Yep. I would agree with everything you just said.
Yeah, pretty much on point. And so that's something to keep in mind. I suppose the question that somebody listening might have is, well, what about the other 70% of people that collectors aren't able to collect from?
Yeah, I mean, here,
There's a
let me
question
tell
out
you
there.
my perspective from being the debt collector.
Yeah, go ahead.
Some people are really hard to find, or it's just not worth the time and effort to find them.
Right.
Right? Like that was the thing that I always ran into was like some people I just couldn't find. So like I'm sending out a process server and doing skip tracing and trying to find people, and they're coming back saying like we have no idea where this person is, and like it happens, and they, so I guess if you want to get out of paying these, like make yourself really hard to be found. What we would do though is we still get a judgment against them, right? So we're going back to the judge and saying we can't find these people, but look at our exhaustive search that we made. Can we alternatively serve them by posting it in a newspaper, or just mailing it to the last known address? And of course that person never sees it. We have the judgment, and then I would go back to the client and say, I couldn't find this person, but here's your judgment if you ever decide to find them and you're able to. So like that's what happens a lot of times. And so I definitely wouldn't bank on that, because a lot of times if you have this old debt and they can't find you, there may still be a judgment out there on
Right.
you that they just don't know how to collect on it.
Right. Right. Yep. And so there's some portion of the population that just has no income, so they aren't going to be sued or collected upon. Some portion of the population that has bankruptcy, they're going to declare bankruptcy. Some portion that's just super hard to find. Some people are homeless, I'm sure, just hanging
Mhm.
out. But if you're here watching this podcast right now, it probably means that you've been found, right? For better, or for worse for you. You've been found. It also probably means that you have some kind of an income right now. Usually collectors get better and better at uh, trying to collect upon people that have some kind of an income, right? Oftentimes a pattern that we see is somebody had a pretty significant income, they lost their income for a while, got into a lot of debt, and now they have a significant income again, and then they get sued for the debt. Right? So it's certainly a pattern that we see. So all this is stuff to keep in mind, right? It helps you out in negotiations, and it helps people understand how to get out of this situation, right? As Solo, we're totally trying to help people uh, get out of the situation, pay back debts that they owe, don't pay debts that you don't owe, but trying to get a pay back debt that you might owe at a discount, and then work towards positive net worth in the future. Uh, we got a question here, and before I get into the next question, if you want to call in the debt hotline at 801-613-8181. We have a next question from an anonymous person. A debt collector has come out of the woodwork after 13 years. I never received a summons to appear in court, etc. He's trying to garnish my wages at work. We are well beyond the statute of limitations in the state of Ohio. I've also looked into local court records that is showing the unpaid credit amount with a few charges. This guy has added nearly 14,000 to this amount and continues to accrue. How do I get rid of this guy? Do I even owe after this amount of time?
All right. So some details that would be helpful, but I'm gonna kind of make some assumptions here. When he says that he's trying to garnish my wages, I assume that like something has been sent to the employer already that's like, hey, withhold this from the paycheck. If your wages are being garnished, it means not only has a lawsuit been filed against you, but the result of that lawsuit is a judgment against you. You can't garnish wages until you have a judgment first. So it's like, oh, they're showing up after 13 years and they're trying to garnish wages, but the statute of limitations has passed. I mean, in some ways, the statute of limitations is irrelevant now. It doesn't matter, because the statute of limitations is not how long they have to collect the money from you. It's when they have to file that complaint by. And if they're trying to garnish wages, it means they have already filed their complaint and they have already obtained a judgment. So unless you can go back and show that the complaint was filed after the statute of limitations doesn't really apply here. So what you can do instead is, since you already have a judgment against you, the way to try and get rid of this is to file a motion to set aside the judgment. And what you're going to do is you're going to, in that motion, say, hey, this was filed way back then. I was never served. I never knew about this until this wage garnishment. So since I was not properly served, please set aside the judgment and take the case back to the beginning so I can respond and fight it. Now, when you're 13 years later, my experience has been like that is hit or miss to win that. A judge may say, hey, this has been sitting around for a long time. Like, I'm not going to go back now. Like, this judgment's been out there. You could have done something about it. And you say, I didn't even know about it. And my experience has been a lot of judges are like, well, I'm sorry, but here we are. But some judges could say, hey, if you were never served and the other side really can't show me that you were served, then, they might set that aside. But that's not going to get rid of the debt altogether. That's just going to start the case over. And really, the statute of limitations doesn't matter because the judge is just going to say, okay, let's start the case over from right here. So statute of limitations doesn't really apply. You can try a motion to set aside the judgment. Probably the best, I would say the highest likelihood of success of getting rid of something like this would be something like solo settle and trying to settle, reach some kind of agreement here. You can try and give yourself some leverage. Like what I might try is like, I'm going to file the motion to set aside the judgment, but before the judge decides that's when I reach out and try and negotiate a settlement because they know that there's a chance that this gets overturned. You've just given yourself a little bit of leverage before you negotiate. So that if it was me, making some assumptions here without knowing all the details, that's probably the approach that I would try.
Yeah, definitely hit on the main points. Yeah, just reiterating here for the anonymous listener. The main thing is you've been sued and you lost your lawsuit and your wages are being garnished. And the statute of limitations that applies is looking at our handy statute of limitations calculator on solosuit.com. Go here, you plug in Ohio. The type of debt is judgment. And it returns, it lets us know that the statute of limitations for judgment debt in Ohio is 10 years, according to Ohio Revenue Code, section 2325.18. So they probably are renewed. So even, this has been 13 years. They probably got a judgment for you 13 years ago. And then they renewed that judgment a couple years ago, perhaps. Very easy to do. They just make one filing, and basically once there's a judgment, it's infinitely renewable, unfortunately for you. And the main difference, maybe it started off as a credit card. Credit card debt statute of limitations is only 6 years. However, for a judgment, it's 10 years, and they can just renew it when that deadline comes up. Yes. So file that motion to set aside judgment and try to get that judgment removed. Definitely going to come down to you being able to prove that you were not served. But like Greg mentioned earlier, it gets easier and easier to serve the harder and harder it gets to serve you. So if the collector can prove it was like impossible to serve you and they tried, at some point they can just publish it in a newspaper and say that was service.
And I have definitely done that before where we're like,
you done that before? How's that even
I-
work? How do you even find a newspaper these days to publish it in?
You know what? There's like newspapers that specialize in printing like summons notice and other legal notices.
Yeah.
Which like who on earth is reading these? Like nobody's reading these. But
That's like all they exist for. It was like the only content that they have.
Yeah. And so like and sometimes the judge will let you just like any newspaper go ahead, but I've had judges that'll say like, hey, look, we're in this county and this is the newspaper that has the biggest readership, so you've got to do it in the classifieds there. But like again, how many people are getting hard copy newspapers these days? Like even if you're reading your local newspaper, you're probably reading it online.
You're not going to the debt. You're not going to the summons.
You're not going to like the gas station and buying like the
right.
The hard copy newspaper to check the legal notices.
Right. Does the New York Times? Does the New York Times have a summons section?
I don't know if the New York Times has it. Does
anybody let us know? Let us know in the chat if you guys are grinding on the New York Times summons service, the service section on the New York Times. But playing the New York Times crossword puzzle and then going over to the
Wordle and
service
reading the legal notices at the
the
same
service section. Yes. If you are doing that, you're probably a lawyer.
Yeah.
There you go. Folks, if you have a question, call the debt hotline at 801-613-8181. Happy to hear from you. We've got a couple questions in the chat here. From Maria. Why is it not illegal for debt collectors to go after really old debt that has passed the statute of limitations?
So I I don't know the laws for every state, but in a lot of states they can still try and collect debt past the statute of limitations by like calling you and sending you letters or whatever. I mean, to people that come to me with that question, I'm just like, just ignore them. Like, you don't have to do anything. If it's past the statute of limitations, they're not going to sue you. And if they do, you're just going to respond with a motion to dismiss saying it's past the statute of limitations. And a lot of times, and most of them, when I see this, the notice that comes to you will say explicitly on it, this debt is past the statute of limitations. And so I'm assuming that a lot of laws in a lot of states will require them to say something like that. So in that case, if it's legal, like who cares? Just don't pay it.
There you go.
That's what I say to that.
Yeah, Maria, there's a particular type of like collector that specializes in post stat, is what it's called in the industry, post stat debts, right? And yeah, they're buying those for the lowest. I think it's particularly hard to collect on those debts because there's no legal recourse.
And I mean, some people pay them because it's like a moral thing for them, right? Like they know it's theirs and they just want to, they feel like they need to pay that debt. Some people I think don't understand the statute of limitations. They're like, "Oh, debt collector's coming after me. I better pay it." But like legally you're not required to.
Got a question from Christopher. I was charged both in civil court and district court for the same case. Is this legal?
So that question's a little bit weird to me because civil court, like, it just means like,
yeah, you just practice in Utah, right, Greg?
Yeah, do other states call it civil court?
Utah has a particularly pleasant court system. I'd say things the court system makes sense in Utah. There's just like one court for each area, pretty like predictable. What are they called in Utah?
Well, in Utah,
they're called district courts.
You've got district court, and then you've got small claims court. But I think I know where this question is going, regardless of the names, right? The question is like, they're suing me in two different courts. Can they do that?
Yeah,
and the answer,
some states have a district court and a civil court that are two different things. Like usually district court will like take cases like 10,000 and above, maybe,
right?
And then like a civil court will take cases between like 5,000 and 15,000,
right?
Something like that.
And the answer to that is, I mean, I guess it's going to depend on state. So I don't want to give a blanket statement because I don't know the laws in every state. But typically, the answer to that is no. So if you are getting sued in two different courts, you're going to look up what are the rules for which case goes to which court. Like you're talking about, George, right? Like there might be a money limit. And like 10,000 and above goes to district court and below 10 goes to civil court or something. Figure out where the case is supposed to be. And then I'm going to file a motion to dismiss in the other one saying, hey, they've already filed this in this other court where it should be. So you should dismiss this second court filing.
Yeah. Would you put that into the answer, or are you just going to put that into like a memo with a motion?
I mean, I would do both. I would put it in my answer as an affirmative defense, and I would also file a motion. I mean, sometimes if you put an affirmative defense in an answer, that doesn't necessarily trigger the court or the judge to do something at that point, right? Like that might be something that you bring up the next time you're in front of the judge or when you get to your trial, whatever, but you don't want to go through the whole litigation process in both cases. You want to get that in front of the judge so the judge dismisses that second case. So I would put it in my answer, but I would also file a motion and, like you said, a memorandum if that's what your state requires.
Yep. Yes. Uh, Christopher, oftentimes what we see in this situation really is the consumer is a little bit confused about what's going on exactly. Court documents can be pretty confusing. I think to verify that there's a case against you in the civil court and a district court, you'll probably want to check like the case number and make sure that there are two separate case numbers. You can also look at the docket for each court, either by calling the court or by looking up online sometimes to see. You just want to verify that your case is in both courts. It also could be the situation that they filed in one court, then they moved to another court. It changed venue for some reason, maybe because the lawsuit amount was actually too high for the district court.
That's what I was going to say. The most likely scenario here is that they filed it in the court with the wrong jurisdictional limit on the money.
Yep.
And a lot of times if I file the case and it's filed in the wrong court, that court will just automatically transfer it to the correct court. So there's two cases there, but they've dismissed the first case. So I would call and make sure that there's actually two open pending cases.
Yes. If and also another key point here, just because the collector made a technical error doesn't mean you're going to win your case. You still need to file an answer. Definitely file an answer document. All right, folks, that's what we have time for tonight on the debt hotline. Thank you all for tuning in, and you can call into the hotline next time. You can also leave us a voicemail at 801-613-8181. Greg, thanks so much for coming on.